The encounter on Tuesday between Governor Babajide Sanwo-Olu of Lagos State and a police officer at the Magodo Phase 2 estate in Lagos once again brought to the fore the impracticability of the current system, requiring a state governor supposedly in charge of security of his state to seek clarifications on security issues within his jurisdiction from extraneous bodies or persons. Is it any wonder that several Nigerians and governors from the southern section of the country continue to clamor for the renegotiation of the current arrangement and amendment of the Nigerian Constitution? Despite the push for restructuring, President Muhammadu Buhari continues to double down on the issue and has again dismissed the calls for state police. In fact, in an interview aired on Channels Television yesterday evening, the president described the clamor for restructuring as noise. Now joining us to discuss the many issues that have been thrown up over the Magodo Estate standoff as a reaction of the Attorney General of the Federation, Abubakar Malami, to the statement by the Southwest governors. We're now being joined this morning by Inebehe Effiong, a lawyer and human rights activist. Effiong will also be helping us make sense of a recent Supreme Court ruling, which declared that the Economic and Financial Crimes Commission, EFCC, could not hide under its Establishment Act to usurp the functions of other law enforcement and prosecutorial agencies in the country. Good morning, Inebehe.
Good morning.
Good to have you, and Happy New Year.
Good morning, Doctor. Happy New Year to all of you.
Yes. Well, quickly, the situation in Magodo. Supreme Court judgment 2012, judgment creditors, judgment debtors, that was not resolved. And then the Shangisha Landlords Association, led by Chief Adebayo Adeyiga, decided to enforce and execute the judgment. And then we had this situation with policemen being sent from Abuja to take over, the Magodo Estate Phase 2. And all of those issues with the governor trying to give instructions to the chief superintendent of police. And people have said this raises a number of issues about the powers of state governors and also about the enforcement of court rulings. What's your take on this matter?
I think it is important to begin by making the point clearly that under Section 235 of the Constitution, there is enshrined the principle of finality of determination of decisions of the Supreme Court. That section clearly states that except with respect to the power of the president and the governor as it pertains to prerogative of mercy, that is clemency, where someone is convicted and a pardon is granted either by the president or by the governor, no appeal shall lie from any decision or determination of the Supreme Court to any other person or body. In other words, the Supreme Court is the apex court, it is the court of last resort. When the Supreme Court of the land has made a pronouncement on a matter, that decision is as good as law. And no other person, not the president, not the governor, not the National Assembly, can sit on appeal to review the decision or determination of the Supreme Court. Now, this litigation started in 1984 when the then military regime in Lagos State acquired land compulsorily from what is now known as the Shangisha landlords. Purportedly, in the public interest, they claimed they wanted to use it for a hospital. It was later realized that these lands were fraudulently, as claimed by the judgment creditors, reallocated to some privileged persons in the society. Of course, they tried to have that resolved. It didn't yield result. They went to court in 1988. The High Court entered judgment in their favor, which was upheld by the Court of Appeal and eventually by the Supreme Court in 2012. I am giving that background to make the point that we wouldn't be where we are today if the culture of impunity has not become an integral part of the Nigerian society. Now, there is a subsisting judgment of the Supreme Court, which remains binding, everlasting. But do not forget that the Supreme Court has also recommended and advised parties to find a way to settle that matter. Unfortunately, efforts by the judgment creditors to enforce that judgment seems to have been thwarted, largely due to complicity of the Lagos state government. Now, Governor Babajide Sanwo-Olu inherited this crisis, inherited this history of injustice. What has he done differently? My perception is that beyond the governor going to Magodo to have that very ignominious interface with the chief superintendent of police, the governor would have resolved this matter earlier. This could have been sorted out if the government had acted more seriously to resolve this matter out of court. Because even after judgment is given, there is what is known as compromise of judgment, where parties, despite being victorious in court, can still compromise on the judgment given to them on certain terms. That appears to have been what should have been done. Now, it is important for Nigerians to realize that for a judgment of court to be enforced, certain preconditions have to be met. Under the Sheriff and Civil Process Act, usually in this kind of case, the judgment creditor has to make an application and file the necessary forms to issue a writ of possession and for the court to make an order mandating the sheriff of court, aided by the police, to execute the judgment. These applications were made a number of times. And of course, it appears that successive chief judges of Lagos State had declined to do so until several petitions were written to NJC and so on. The point I am making is that when you have a state like Lagos that has an anti-land grabbing law, and the state is the one that is the land grabber, who is now going to ensure that the right thing is done? That is what this is about. But I do agree that some of the occupants of these properties in Magodo may also have been victims of circumstance, having purchased these properties possibly without knowing the genesis of this matter. But whether they knew or not, people have developed those properties. It becomes a bit difficult to just throw them out and ask them to get another plot. Therefore, since the government has now issued a statement that a resolution is on the way, I am hoping that the governor will live up to that promise and resolve this matter and allot the 549 plots to the persons. Now, regarding what happened between the CSP and the governor, should the governor have been there in the first place? It is a bit complicated. Really, because ordinarily, people say, well, the governor is the chief security officer of the state, even though that is not in the constitution. I've always highlighted that point. Now, that expression, chief security officer of a state, is not mentioned anywhere in the constitution. It is only
215 subsection 4.
Well, the specific wordings is not used. What 215 says is that the governor may give such lawful directive to the commissioner of police. But there is a caveat, there is a proviso, yes, that the commissioner of police may make a referral to the inspector general of police. So when you now have the IG, delegating a team of police officers, dispatching policemen from Abuja to come to Lagos, why didn't they go to Zone 2? Why was the state command not used for that operation? Why did they have to come from Abuja? The police in Nigeria today is about the most dysfunctional in the world. The police in Nigeria today operates on a foundation of impunity and lawlessness. And guess what? The governor went to that place with CP Odomosu, the commissioner of police in the state, who ordinarily should have been the ones to execute a judgment, supposing there was a judgment to be executed. Of course, there is a judgment to be executed, but the point I'm making is that if the process had been followed, it is a CP who should have supervised that process. They didn't have to send police from Abuja. What that shows you is a police that is dysfunctional, is a police that operates on a divide and rule. And of course, you had the governor trying to tell the CSP to stand down, and he said, no, go to the AGF. Now, people are saying, has Malami done anything wrong? Again, you must also look at it from two ways. The first is that the Attorney General of the Federation is a chief law officer. That is what Section 150 of the Constitution says. And when you look at his powers under Section 174, he has expansive powers as it relates to enforcement of law. My concern is that Malami acted selectively. Because if you look at his antecedents in the last 6 years, you cannot tell me that you have a chief law officer in this country. You cannot tell me that you have an attorney general that truly believes in fidelity to the rule of law. So when he now comes out to say that why was the judgment not enforced, it is a valid question to ask. But this same attorney general has supervised serial infractions, serial disregard of court orders. So what is his interest in this specific case? But I do agree that because the Lagos state government had made it almost impossible for this judgment to be enforced, maybe this unfortunate episode will now be the trigger for this matter to be resolved. The position of the Southwest governors, again, is also very interesting. Because they have said, oh, that this is a call for true federalism, and the president has said, oh, I don't believe in state police. I understand the concerns. I am one of those who are genuinely concerned about abuse of state police. Imagine, Dr. Bati, imagine for a second that there is a Lagos State Police Service or Lagos State Police Force on that day, and Sanwo-Olu as the governor went there and told the federal police to stand down and they refused. Can you imagine what would have played out? I agree that at some point this is a conversation that Nigeria must have. But Nigerians must also be honest. Governors have become constitutional vandals. Governors have become the greatest violators of the constitution in this country. So when we speak about these things, the reality is that I do not know a single governor in this country, one, that truly believes in the constitution. They have desecrated the local government system. They have desecrated the state electoral commission. They have desecrated the state judiciary. Some of them have even annexed the judiciary as part of the Ministry of Justice. So if you are now going to establish a state police under this climate of impunity by governors, you must ensure that you put the necessary checks in place to ensure that they do not turn state police to private militia, which is even what they are doing now. So I also have that fear. But this is not to make an excuse for the statement of the president, who came to power on a promise of restructuring. And they set up a restructuring committee headed by Governor Nasser El-Rufai, which submitted a report. That report was thrown into the dustbin of history. So when Buhari is speaking hypocritically that the issue is about governors and local government, what has he done since he became president to address a single institution in the last 6 years? Not even one has been reformed. Not even one. Look at the madness with the Electoral Act Amendment Bill. The executive stood there. They watched all this played out. The president, who has turned the leadership of the National Assembly to his yes men, couldn't invite Lawan, couldn't invite the speaker and say, this is my position, for them to harmonize before the bill was passed. Suddenly he rejected it. What is the point I am making? This position of the president, it is better than founded in hypocrisy. So we shouldn't see that, oh, we have a president who is afraid that governors will abuse the police. Has Buhari not abused the SSS? Has Buhari not abused the police? Has Buhari not abused the military? So you have a situation where Nigerians are being held hostage by the president and governors. That is where we are today.
So many nuances in all you've just said. I'll start with the Supreme Court judgment, which, according to the statement, which I'm sure you read by Lagos State, the Supreme Court judgment gave first choice preferential treatment on allocation and reallocation of 549 plots, not possession. I'd like your comment on that.
No, let's not mix up the issues. When this matter arose in 1984, people were occupying their properties. The military came, took over those properties, claiming, of course, the Lagos State government, because government is a continuum, that this was meant for public purpose. Right? Because under the Land Use Act of 1978, land can only be compulsorily acquired principally on two grounds, either for varying public interest or for public purpose. Now, those plots that were illegally reallocated to private persons, in the eyes of the law, and this is not the first time that we have had this kind of matter pronounced upon by the Supreme Court. We also had it in the case of Estate of Lesani Abacha v. A.K. Spieth, where the Supreme Court also made a similar pronouncement. There have been litany of cases that once you acquire land for a public purpose of varying public interest, and you subsequently use that land for another thing, for private interest, or private reallocation, that acquisition is a nullity. So let us not say that what the Supreme Court did was only that they should be given preferential treatment, because the issue of acquisition was determined that it was illegal and unconstitutional. And because that was the decision of the Supreme Court, what happened was that while this case was pending, if you have gone through the judgment, there was some attempt to have that matter resolved. But the Supreme Court also understood that these properties have been developed by some other persons. Now, the issue is not whether possession was ordered, because if we are saying that possession was not ordered, the implication would be that it was not an enforceable decision. You cannot say somebody has taken my land illegally and then say, I cannot take possession. So what were they going to enforce, really? What were they going to enforce? If there was no possession, order as to possession, there was nothing to be enforced. There was no enforceable judgment. Because that would mean leaving the judgment creditors at the mercy of the judgment debtor. That whenever I am ready to reallocate, I can reallocate. But the good thing is that all this is now hopefully in the past, that the Lagos State government will swallow the humble pie, give these people back plots, and resolve this matter amicably. Because they said that is done. This is going to continue. And I must also say this. Every governor in Nigeria, before he begins to perform the functions of his office, the Constitution says he must subscribe to the oath of office and oath of allegiance. Part of that oath is that the governor shall uphold the Constitution and the rights of the citizens. So you have section 287 of the Constitution on enforcement of decisions of courts, which places an obligation on the governor to ensure that judgments of courts are enforced. But don't forget, in all this, I have said that the reason why Malami, the police, can afford to do this is because possibly somebody knew somebody that spoke to somebody. Because I have also had a client whose property was taken by the Nigerian army. Number 3, Carrington Crescent, just by the American embassy. This man had been there since 1975, before the Federal Inland Revenue Act was enacted, that now made his land form part of what is called the inland waterways. Guess what? The military took this man's land, destroyed his boat and everything. He went to court, got judgment. I wrote to the same Malami, to the same Attorney General, to help us enforce the judgment. Nothing has been done. Several Nigerians have written petitions to Malami to help them enforce judgment of court. How many have they done? Even judgment that we get against the federal government, Malami frustrates them. When you get judgment against the police, you get judgment against the army. The law says you should get the Attorney General, the consent of the AG to enforce it. How many persons has Malami given consent to enforce judgment against the federal government since he became the Attorney General? How many? Let him come up with the number. The point that I'm making, Dr. Bati, is that beyond the euphoria that we have an Attorney General that wants to enforce judgment, we must also say clearly that this is about hypocrisy, this is about self-interest, but in all that, we must never compromise the rule of law. When the Supreme Court has made a pronouncement, whether you like it or not, it is in the interest of all to ensure that that pronouncement is obeyed.
Okay, so speaking on that, just to get the angle right, I think those that they got the judgment in their favor, in fact, there was a statement attributed to them that said they commended, the very strong role of the Attorney General of the Federation in helping them get justice. That is a man of honor. I mean, they said all the great things about him. So obviously, you know where that comes from. Obviously, they contacted the Attorney General. But the area I want to dial back is the drama that happened that day on. Let's not forget that prior to that time, a week before, the CP was first sent to that same place to calm things down. But the police officers that came from, Abuja didn't listen to the CP in Lagos. He went there a week before. It was when that wasn't successful that the governor had to intervene. What does that say about the state of play of things? Because all I see here is just too many power show. From the federal level, to the state level, to devolution of power, to even this talk about restructuring. That speaks volumes. It just shows that according to the police hierarchy, if he gets an instruction from the top, the CSP, because of who instructed him, can violate the orders of the CP of the state.
The truth of the matter is that the police, like other security agencies, they function based on a chain of command. You have the IG at the pinnacle. And of course, that trickles down to the divisional police officers. Now, within the chain of command in the police, when the IG has taken a position on the matter, there is no commissioner of police that will listen to any governor, not even one. Because the Constitution allows what looks that to happen. Even though many have said it is an aberration, but that is what the Constitution says. So you have a situation, because I started by saying that don't we find it a bit upsetting that the IG did not instruct the state command to carry out that assignment? Don't you find it a bit interesting that you have Zone 2, that is superior to the state command in Lagos, and the AIG of Zone 2 was not mandated by the IG to carry out that judgment? Think about, let's even leave all this. Think about
and don't you also find it interesting that this same CP has been promoted to an AIG position?
No. Yes, before we get to that, but think about even the cost implication, the logistics of bringing those policemen from Abuja to Lagos. It could have been used for more serious things. Now, the CP is now an AIG, but that doesn't count in the scheme of things as far as this matter is concerned. I started by telling you that the reason why this happened is because the judgment creditors have a long leg. Not many Nigerians have been able to get the police to assist them to enforce judgment. I'm telling you, we live in a lawless country. In the case I cited, even when the police, the court, Federal High Court directed the police to assist my client in enforcing the judgment, when the soldiers chased the policemen away, they chased them away. So what you are seeing is a country that functions in dysfunction. A country that thrives on impunity. Because ordinarily, why are we having this conversation? We're having this conversation because you have institutions of state being privatized, being weaponized to serve personal interests.
Okay,
that is it.
Let's move this conversation forward. I mean, I agree with most of the things you have said. But what has happened in Lagos is really not extraordinary. There have been cases, even in history, when state governments would oppose a decision of court for all kinds of reasons. Brown versus Education, 1954 in the US. The recent case of creation of a local government in Lagos State, even with the Supreme Court ruling that those local councils were illegal, the Tinubu administration did not immediately obey the court and so on and so forth. And in this particular case, the Supreme Court in 2012 recommended amicable settlement. I think the question is, why is it that since that 2012, every attempt to arrive at an amicable settlement in Lagos State has not worked, right? Now, you said the Attorney General of the Federation is selective. Well, I think many people will agree with you in that regard. The matter, from the point of view of the judgment debtors and the Magodo Residents Association, is simply that, look, the judgment creditors apply for a warrant of possession and warrant of execution, and there is still a subject of appeal, right? There was an appeal, there was a cross appeal, and that it will appear as if the Shangisha Landlords Association is resorting to self-help. So there are many questions. However, the governor went there. You said he shouldn't have gone there, but I thought he helped to maintain peace, because the situation was going to degenerate into anarchy, chaos. Yes. And yesterday, they had a meeting, which is where I'm going. And the governor was even commended by all the attendees for providing good leadership. But the question is, do you think that the matter can be resolved this time? 6 resolutions reported on page 48 of this day, newspaper today. One, that the committee that has been set up by the governor will look into this matter and meet with the judgment creditors. Efforts will be made to identify if there are still plots of land, vacant plots of land, and these 549 judgment creditors will be given compensatory plots of land, whether they will agree or not. 3, if there is no more, available space in the Shangisha Magodo area, the government will offer them an alternative in another part of the state. So what do you think of these steps that have been taken as a way of resolving the matter?
quickly, two things to clarify.
Yes.
My position is not that the governor shouldn't have gone there. I said it is a two-way thing. Because in one breed, the judgment debtor is the state, the Lagos State government. And the governor is the chief executive officer of the Lagos State government. So it is an interested party. That is the point. The other point is that if he didn't go there, anarchy would have ensued. People could have lost their lives. Imagine a property you've developed and somebody just bring, trailer and pull it down. Crisis would have erupted. So he had a duty. He had a duty as the chief executive officer of the state to forestall that from happening. The second point is that, which is what you have brought up, I have read in details about this matter. I'm aware of the subsisting appeal. In fact, there's even an application, a certain motion for injunction to stop what eventually happened. By the doctrine of least pendants, one would have expected the judgment creditors to await the outcome of that process. Part of the reason why this matter has not been resolved is because the judgment creditors are divided. We must make that point. It looks like there are two factions within the judgment creditors. One faction is more aligned with the government, while the other faction, seems to have a different perception about it entirely. That was why, in fact, that was the basis for the applications to set aside the writ of possession. Because they said that, I think the Adeyiga, Yes, faction did not have the mandate of all the judgment creditors to make that application for writ of possession. It was on that basis that they went on appeal, and that matter is pending. But Dr. Bati, it is not the duty of the police ordinarily to enforce judgment of court. Nigerians should get this clearly. It is a duty of the sheriffs of court, aided by the police. Under the Sheriff and Civil Process Act, the police is to assist. So the question is, which sheriff of court, which is a valid question, was there to enforce that judgment? That is why I say that this was more about personal connection, personal relationship, and you see how patronizing the judgment creditors were in their statements, about the Attorney General. You see how they patronized him. They said, oh, he's a square peg. I said, who are they talking about? It's still the same malam that all of us are conversant with. So you have made a valid point. But these 6 points, I believe they are implementable. I believe they are reasonable. And in fairness to the governor, he seems to also have shown some leadership, at least lately, about this matter. He should have convened that meeting before now. But I am hoping that it will go beyond press statements. It will go beyond the public show, the public relations propaganda, and ensure that this matter is resolved and put to rest. And not only that, all similar cases in Lagos, they have this monile mentality, madness that is going on. You are in a property, somebody just wakes up and take that property from you.
Well, if I could just come in here, so many questions to ask and agreements and disagreements based on what you said, but we don't have time. That Omonile mentality might be what the president was referring to in his interview with Channels, talking about how what obtains in the south is different from what obtains in the north. But we need to move on. I want your take on the Supreme Court judgment that curtails the powers of the EFCC regarding the SAN Joseph Nwobike.
I will be a bit cautious. I will be a bit cautious. Did the Supreme Court necessarily curtail the powers of EFCC? My understanding of that judgment, which some lawyers have expressed reservations, and I believe they should be listened to, is that if you look at the facts that led to the charge being filed, did the senior advocate of Nigeria, Nwobiko, did he have questions to answer? As far as I'm concerned, I believe so. Were his answer satisfactory? That becomes a question of debate in the light of the judgment of the Supreme Court that has overturned his conviction. But of course, the Supreme Court has cleared him. The Supreme Court has acquitted him. That because the charge preferred against him, there was an allegation of an attempt to influence, to corrupt the judicial process, the court of justice, and so on. There were allegations. I say allegations because he has now been acquitted, that he tried to influence assignment of cases. Some messages were shown to have been exchanged. But the matter went to court. He was convicted. He subsequently went to the Supreme Court. And a lot of issues arose. The prosecutorial powers of EFCC, is it limitless? Can a state, in this case, if you look at the offense under which he was charged, under the criminal law of Lagos State, there was a question as to the definition of that offense, the ingredient of that offense. I think I went beyond that to say that even if the offense was clearly defined, does the state have the legislative capacity to make an enactment relating to the basis upon which he was charged? Because the judicial officer in question, they're not under the control of states. You know, the allegation was that he tried to bribe a judge, or that he bribed a judge. It was a federal. Now, beyond the legal niceties, I am one of those who have beginning to question seriously the modus operandi of EFCC. EFCC looks like they want to step into the shoes of Sars, the Notorious Special Anti-Robbery Squad. The way they are going about prosecution now, they have gone overboard. And this is not the first time EFCC is being implicated by the courts. There have been series of judgments where EFCC will place direct banks to freeze accounts of customers without resorting to court. The court has also ruled that EFCC has no such power. So I don't think this is a setback on the powers of EFCC to fight corruption. Because I believe, and this is my personal opinion, which is why I said I'll be careful about what I say about the technicalities of the judgment. This is my personal opinion. I believe that there is a problem of corruption in the judiciary. And every successive chief justices of this country have admitted to that. There is a problem of corruption. And Dr. Bathi, in most cases, the lawyers who are mentioned in connection with those key matters, they are not young lawyers like us. They are always people who are up there. Because those are the people who have access to judges, who could have been their colleagues in school, who could have been their friends. There is a problem of corruption in the judiciary. So when you have a learned senior advocate, that is the pinnacle, that is the height of it, the highest honor. You know, being accused of certain things, you must also look at the merit, because this was more of a technical judgment, with profound respect to my lords at the Supreme Court. It looks more like a technical judgment. The real substance of the allegation against him, it appears that aspect of the matter was not addressed. He may have escaped on technicality, but we must look at the legal profession in this country. The relationship between the bar and the bench must be closely looked at. No judge. There are very few judges. The few judges who take bribe, in many cases, lawyers are involved. How many lawyers have been convicted for bribing judges successfully? How many? So there is a problem, especially in political matters, election petition. Especially in political matters. The Supreme Court, I believe, will also think about, because it's also a court of policy, about the implications of some of these decisions. You know, there is already the Court of Appeal judgment that...
There are many issues arising from what you have said, but I'm sure Rufai has something for you, so I'll just hold my fire.
I mean, I would have taken that up, but time is not our friend. I'd just like to say a very big thank you to you, Inebehe, for your time, and come back to you, Dr.
Okay. Well, Inebehe, the issue about the things you just said now, are you asking for a review of the EFCC Act? Because, you know, this is not a new argument. And under the EFCC Act, the EFCC lawyers have pointed out that, you know, they have a scope within which, you know, they can expand or within which they operate, and that the EFCC Act enables them. Is it a question of, you know, lack of clarity in some of the sections of the EFCC Act? But unfortunately, we don't have much time. We want to thank you very much for joining us this morning.
Thank you.